Right, that's it's going. So, morning everyone. Welcome to this Gravita webinar about demystifying COP8, COP9, and ADR. Bit about Gravita in case you don't know us, or many of you I suspect will. We're a top 40 accounting firm, 400 team members working for us, and we're a full service accountancy firm. So we're big enough to offer advice on everything, so capital goods, company secretarial, corporate payroll, outsourcing, private clients, research, development, VAT, and anything accounting related or tax related. We have enough people within our 400 strong team to be able to help you with that. We actually focus on a couple of areas where we consider ourselves specialists, and that's sort of life sciences, charities, education, technology, and financial services, but particularly property. And we're getting bigger. So now we've got a presence there, and we aim to get bigger and bigger and offer better and better services. We're part of the DFK International Network, which means we've got a global reach as well. So any accounting or tax issues that we can help you with, do just shout out to your regular Gravita contact, and if not, by all means contact me and I can point you in the right direction, or our marketing team or our client services team. So we're all here to help, and we're being enough to help things. A bit about me. I lead our tax investigations, disclosures, and dispute resolution service at Gravita, and we represent clients in all areas of tax, right from a local inquiry, a Section 9A inquiry, right through to the tribunal. That's the first tier tribunal, where we will decide whether we take cases ourselves there or instruct counsel, or the upper tier, where we'll instruct counsel to take cases at the upper tier. Any contact with HMRC in any of its guises, we can help with. And we advise in all aspects of that, from fraud investigation service investigations, and we'll come on to what the fraud investigation service is and what they do, and give you a bit of insight into COP8 and COP9, which they alone deal with. I'm also a private client practitioner, and sort of advise widely on estates, trusts, and international tax planning. But today is all about the tax investigations, COP8, COP9, and ADR, and that's what we're at. So let's talk about the Fraud Investigation Service. Who are they? What do they do? They're a division of HMRC. They're a specialist division of HMRC, and they consist of about 5,000 people that work within FIS, according to HMRC. According to the Civil Service Careers website, there's about 5,000 people in the Fraud Investigation Service. It really was an elite service. So 10 years ago, when dealing with fraud investigation service, you knew that you were dealing with an inspector who was at the top of their game, who had experience, and was pretty good to deal with because they were on that sort of level. The people that work for FIS has expanded now, so there are varying levels of experience of officer that you get when you deal with them, and that shows sometimes. But they also have other professionals that work with them. That's forensic accountants, cyber crime investigators, and insolvency practitioners, all part of that fraud investigation service. And they use both civil and criminal powers, which we'll come on to in a moment. And the phrase they use is they investigate the most harmful tax frauds. There's a difference between evasion and avoidance, as many of you know, and we'll come on to how HMRC see that difference in a moment. But essentially, that's what the Fraud Investigation Service is there for. It's a specialist wing of HMRC that looks to tackle what they say is the serious tax evasion and avoidance. According to HMRC, the FIS, so when I refer to FIS, it's Fraud Investigation Service, the FIS applies you that the tax year ending April 24 was about 5 billion. So there was corporation tax within that, they say, of about 762 million, excise duty of 1.5 billion, income tax of just over 1 billion, VAT the same, just over £1 billion, and the other taxes and things that HMRC deal with, 440 million. So clearly pays for itself. 5,000 people getting in 5 billion is a pretty good return on their investment, if you like. So there is a civil service careers website if any of you are thinking about joining the Fraud Investigation Service or want to become part of their team. You can go onto the civil service careers website, type in Fraud Investigation Service, and there are some open roles, I believe. So if you fancied that, go and have a look there. So what sort of cases the FIS handle? As I say, they're a specialist unit. They focus on suspected tax fraud, so that's evasion, and avoidance. So they have two codes of practice that deal with that. Code of Practice 8 is where they deal with avoidance, and Code of Practice 9 is evasion. So COP 8 and COP 9 as, arguably, you could say good cop, bad cop. And I don't know which one's which. Some people say COP 8 is the good cop because Code of Practice 9 deals with tax fraud and evasion. But we'll come on to what they mean in a minute. But I think it's probably the other way around. I think if you can get into Code of Practice 9, that's the good cop, because there is a guarantee that HMRC won't prosecute you in Code of Practice 9, whereas they could prosecute you in Code of Practice 8. So what's a good cop, bad cop? Also deal with criminal prosecutions. They used to deal with it themselves, but most of the time now it's dealt with the Crown Prosecution Service. And that's where they, a bit like the police, they put a case together and then they ask the Crown Prosecution Service for a charging decision. And that's whether the CPS authorised them to put charges, in which case the CPS will then prosecute it on behalf of HMRC alongside. So the HMRC role in that is to support the CPS in prosecuting where they believe it's in public interest. According to HMRC, in 2023-24, they had criminal proceedings where they executed 648 search warrants. So that's an entry warrant. So that's a warrant where they can enter premises authorised by a court. It's a warrant to be issued by a court. They're authorised to enter premises, a raid, if you like. They had 648 of those in 23-24. There were 501 positive charge decisions. So that's CPS authorised HMRC based on the evidence they've given the CPS to lay criminal charges, which then the CPS will pick up and prosecute. Of the 501 positive charging decisions where the CPS authorised the charges to be laid, 344 were actually prosecuted. And that resulted, according to HMRC, in 302 convictions, and there were 42 acquittals. So, and a conviction, remember, is not just a trial. If somebody needs to be acquitted. So, how many of those were trials, I don't know, and HMRC didn't specify, but 302 convictions from 344 prosecutions is a reasonable return again on their investment. And just as a buyer, the sentencing breakdown for that, what the judge gave by way of punishment in those cases, there were 142 custodial sentences, so terms of imprisonment. And of those 42 prison sentences, total months that all of them came to was 4,874 months. So that's an average of about 34.32 months per offence. And that's, some people will get 6 months, other people will get much longer, but the average of that is just short of 3 years. So when HMRC prosecute, they prosecute with a view, obviously, to sort of get quite a high number of those convictions. Now, remember, the convictions are 302, so just short of half of them result in a short-term, an immediate custodial sentence, on average, of just short of 3 years. So it's something to be mindful of. And the accountant or tax advisor can play a role in defending prosecutions. So where a criminal solicitor is instructed to defend someone that's allegedly evaded tax, the accountant's and tax advisor's role is to support the solicitor in that, is to do the analysis work the criminal evaluation and become an witness, like possibility of evidence, and we can do that as well. Apart from the immediate custodial sentences, there are suspended sentences. So that's where the custody threshold, the threshold with which to send someone to prison has been passed, but the judge has decided for any reason, for various reasons, not to activate the term of imprisonment immediately, and that's to suspend it. And 65 of suspended sentences was given in 23, 24, and an average of 1,211 months for all of them. So that is an average of 18.63 months. So even where a suspended sentence was given, it's just around about a year and a half custodial time. For those of you who don't know what a suspended sentence is that you're not sent to prison immediately. You might be asked to do some community sentence work as part of that suspended sentence order. But if you commit another crime within the operational period of the suspended sentence, you'll be called to and you'll serve that crime punishment for the next crime. So FIS are pretty good when they decide to take cases on a criminal footing, are pretty good at securing convictions. Most cases clearly don't go with the criminal prosecutions and go through the civil procedure, and that's where Code of Practice 8 and Code of Practice 9 come in. So Code of Practice 8, and you'll recall that was the avoidance where HMRC believe that someone's avoiding tax. And it's a civil investigation, it's not criminal. And a COP8 investigation is usually where FIS I've got intelligence that the taxpayer has used a marketed scheme. They've got into a scheme that's been widely marketed. The too good to be true schemes are sometimes called. And deliberately, I use that term advisedly, but a consequence of going into that scheme has meant that their tax has been reduced or avoided. And that could be an individual, a partnership, traditional partnership, or an LLP, a company or trust, any entity. FIS are well able to look at any entity and very often follow structured entities where there's layers to help throw HMRC off the scent, if you like. And that could include offshore structures as well. So they're very able to deal with that. And they cover all taxes, duties and levies and contributions for which HMRC are responsible. So there's nothing off limits for FIS to look at under Code of Practice 8. Before they issue a Code of Practice 8, they would have done some background work. And I don't know because I've never worked for FIS, but it's almost certain that they have done some background work before they go and issue a Code of Practice 8 notice. What usually shocks them is that some intelligence somewhere and they go and look at it. Their software, Connect software, draws in information from all over the world, from all over government departments, from websites, and it creates a picture of a taxpayer and it builds a risk profile. So before a Code of Practice 8 is issued, almost certainly that would have happened. But it's important to remember that Code of Practice 8, even though it's dealt with by the Fraud Investigation Service, a specialist service, is nevertheless an HMRC investigation. And that means that they are bound by the assessment time limits, as in the case for any other investigation or inquiry. So those that were on my seminar earlier in the year will know about assessment time limits, or you may know them anyway, and it's, they can only go back 4 years if there's reasonable care, 6 years if there's carelessness, 12 years if there's an offshore element, and that's irrespective of behaviour. So could have taken reasonable care or been careless, and they can still go back 12 years if there's an offshore element to that. There's 20 years for deliberate behaviour, which is important in the COP9 bit, which we'll come on to. It's 20 years where you fail to notify your master. So those set time limits are still relevant for a Code of Practice 8 investigation. So if you have one and you're dealing with one, those time limits are still there, those assessment time limits are still there. And remember that incumbent on the taxpayer to prove reasonable care was taken by them, and the error occurred despite them taking reasonable care. But it is incumbent on HMRC to prove any other behaviour. So it's incumbent on HMRC to prove balance probabilities that there was cases already deliberate. And that's important to remember. In terms of numbers, HMRC say that there are currently 937 Code of Practice 8 investigations going on. And not necessarily opened in the tax year 23-24, which is what I'm talking about. 212 were opened in that year, to 24. 314 were closed in that year. But here's the interesting bit. The tax, the revenue from Code of Practice 8 investigations in that year, or the total amount they took under COP 8 was 83.2 million. And that was 74.8 million in tax, 6 million in interest, and only 2.4 million in penalties. Now, what that suggests to me, that's an average of 3.2% penalty per case. That's very, very low. And clearly, where there is a penalty, the percentage will be higher than that. So what that suggests to me is that a lot of cases on the COP 8 settled where HMRC accept the taxpayer took reasonable care. And that sort of fits with the things that HMRC investigate under COP 8. So a taxpayer may have been, gone into a marketed tax scheme, taken advice, being told, given counsel's advice, where the sort of the scheme promoters say, here we took advice from counsel, asked their accountant maybe, that said, yeah, I can't see anything wrong with it, but take care. That's taxpayer, they do what they could have done to make sure that they pay back the tax. And it seems, given that low level of penalty, if that's correct on HMRC's figures, then it does appear that HMRC do accept that the taxpayer took reasonable care, even though they're in these marketed schemes. FIS, when they look at a tax return under COP 8, they might look at one aspect of a tax return. It might be as part of an ongoing inquiry. There might be an inquiry under Section NA, and where a local inspector is looking at a few things, and FIS might only just be looking at one aspect of that return. And they could limit themselves to that one aspect and allow the other officer to deal with the rest of it, in which case FIS will coordinate the inquiry and the local officer will be coordinated by them. Or they may take it over. They may say, okay, from the local officer, we'll take over that inquiry as part of our investigation as well. And that's very much up to them. And that will be led by FIS. So the local officer will do what FIS asks them to do because they're the senior investigating arm. So that's COP 8. They are serious. The COP 8, it's important to know the legal framework of COP 8, and that is the usual framework of any other inquiry. So the assessment time limits I've spoken about are important, and the legal framework of the inquiry itself is important. If a Schedule 36 information notice has been issued, those that will remember my webinar earlier in the year, you've got to look at the framework of that, whether the request's lawful, whether there's a reason to suspect, whether any information is reasonably required, or it's too old. So you've got to keep an eye on that. Also keep an eye on are HMRC in a position to make a discovery assessment. You'll remember under discovery, the first hurdle is on HMRC to show that they're in a position to make a discovery, i.e. they've got information they didn't have during the inquiry window, and they could only get that information after the inquiry window closed. So those tests remain, and it's important to have those at the back of your mind before you hand over everything to HMRC. So Code of Practice 9 is different. It is still a civil investigation of fraud, but it is where deliberate tax evasion has taken place. Now, one of the conditions for entering COP 9, whether it's offered by HMRC or it's something you've applied to get into, is the taxpayer admit that they have done something deliberately. If your clients or you are adamant you haven't done anything deliberate, then Code of Practice 9 isn't for you. It really is as simple as that. It is only for deliberate behaviour, where you want to go to HMRC and say to them, I've done something deliberately and I want to correct it. There are conditions for COP9 and there are ongoing conditions, but it is a civil investigation of a tax fraud dealt with under the tax code as opposed to a criminal investigation dealt with under the Police and Criminal Evidence Act. So it's valuable because if you're in COP9 and you admit you've done something deliberately and you want to make a complete, accurate, open and honest disclosure of all the behaviour bringing about a tax loss or duty or payment administered by HMRC, as they put it, then it's the right facility and you have the comfort that you won't be prosecuted. You won't be prosecuted to the extent what you've told them. If there's something you don't tell them, they can still prosecute for that. So once you're into COP9, it really is time to unload everything and tell them everything you've done within the assessment time limits. And it's a great way to think we'll show as well in COP9. The pillars of HMRC always reserve the right to pursue a criminal investigation where appropriate. Now that, within the COP9, that means that you've got to cooperate, you've got to do what they say, and you've got to tell them everything deliberate and non-deliberate. Otherwise, they can take you out of COP9. If you do everything they say and you cooperate, they won't take you out of COP9, and that's where you're protected from a criminal prosecution. So it's always important to remember. If you don't, I'll come on to a case later where someone didn't mind and they're taken out, and we'll know who it is, but I'll mention that case later. So have that in the back of your mind, that if your client is in COP9, it doesn't mean it's the end of it, it means it's the start of it. You have to cooperate. If you don't, you'll be held to account and you could be prosecuted. So how are COP9 started and where do they come from? Well, they're started in one of two ways. HMRC write to you, write to the taxpayer, or you can apply to be admitted. Either the start's different, the process is the same. HMRC write to your client, the taxpayer. They say we're investigating suspected serious tax fraud, and they give you an option. On the letter, they say, look, do you accept you've done something deliberate and we'll put you into Code of Practice 9, or do you refuse their offer to go into Code of Practice 9? And you have 60 days from that letter to make up your mind. So 60 days in which to go and get advice from someone who's skilled in COP9. For those of you enough, you might remember that there was a third option many years ago where you could say, I deny deliberate behaviour, but I'm happy to help. That's gone. And it's either now you accept or you refuse. And the alternative is you apply to go to COP9. So very recently we had a client come to us, was referred to us, and engaged in deliberate understatement of income for a number of years, admitted up front that it was deliberate, and there wasn't anything else other than deliberate. So we applied. So HMRC obviously didn't know about it, so we applied to go into COP9, and were admitted into COP9, and we've just submitted the contractual disclosure facility report. So you can apply, and you know it's the right thing to do if you've got a client that says, "Look, I've done something deliberately," because it's the only investigation, only system of investigation where that client is guaranteed not to be prosecuted. Part of the COP9 is that you it's a controlled disclosure facility report. So entering into Code of Practice 9, you have to agree that you enter into a contract to disclose all of the deliberate behaviour and say, well, you know, this is what I've done. This is the deliberate act that I want to highlight. But in addition to that, I want to tell you about all the other errors that I found in my taxes when I look back, whether they're deliberate or not. But in order to get into COP9, there has to be deliberate behaviour. But once you're in, you can tell them everything. And you know, ways to really wipe the slate clean and start again. You have to submit an outline. So if you're admitted into COP9, HMRC accept you into COP9, then you have 60 days to make an outline disclosure. Where you apply to go into Code of Practice 9, HMRC will do some background checks before they decide whether to let you in or not. They'll do some background checks to make sure that you're not under a criminal investigation. Someone else is criminally investigating the taxpayer, and they will do a background check to sort of get a lifestyle, a feel for your lifestyle in a way. So if you apply to go into COP9 and are admitted, then you have to give a disclosure, an outline disclosure within 60 days, and that's essentially, what you did, how you did it, who else was involved, were there other people, was it just you, and over what period. So it doesn't have to be a full and frank disclosure at that point. It just has to be enough for them to say, okay, well, look, clearly there is something going on and we want to know more about it. Once that's gone in, you then need to submit a formal disclosure, which is a disclosure report. That's very often prepared by a specialist. So we have just prepared and submitted a CDF report to HMRC with that case that we applied to go into that I just mentioned. And part of that is you look in detail of, you give the background to the person, company as well, if it's one of the company. You give all of the details that you can possibly give, all of their reference numbers, national insurance number, UTR, VAT numbers, background, date of birth, where the directors, what they're involved in, their lifestyle. You then move on to say what they did, how they did it, why they did it, calculate all of the taxes due. So, with a company, that could include, if you took cash in hand and you didn't put it through a company, you understated the company's income, so there's corporation tax liability there. But if you put the money in your pocket, you've also got to think about, well, how did you get the money out of the company then? Because that company was it pay-as-you-earn salary that you didn't operate pay-as-you-earn on? Was it a dividend? If so, did the dividends fit the requirements of the Companies Act? Was it a lawful dividend? Was it declared in the accounts? Were there distributable reserves? You've got to think about all things like that. If it's none of those, was it a debit from your director's loan account? In which case, is the DLA overdrawn? And if so, have you missed a Section 455 charge? So those are the things you've got to follow it all through and think, what all of the taxes have I missed? So you calculate all of the taxes that are involved on that. Was VAT due on that? Was that the gross amount or the net amount? Those things. You've got to take a view on that and put all of that in the report, come to a conclusion about all of the taxes that have been under disclosed, and then write a report about that, give it to them, calculate the tax, calculate the interest, and then calculate the penalties as well, and then make an offer. So there's quite a lot involved in the CDF report, and HMRC can challenge it. Once you submit it, they can challenge it, they can talk to you about it, and it's important that you cooperate with them. There are formalities to a CDF report when you submit a CDF report. Formalities are, you've got to, once it's agreed by HMRC, and they might come back and challenge it, or they might come back and I want to talk to the taxpayer. And remember, if you don't cooperate with that, then HMRC might see that as a sign of non-cooperation and take you out of COP9. But once the report's in, it's the whole discussion. You've done the hard work. The taxpayer will be prepared to adopt the report as their own. So we might prepare the report, but the taxpayer will be required to formally adopt that report and say, "This, I agree with everything in it, and this is my disclosure." And that's a requirement, that it's their disclosure, and they adopt that report. When HMRC accept it, there's an agreement, has to pay the tax, interest, and penalties, obviously, but they'll also have to sign a statement of worldwide assets and liabilities. And this is because HMRC wants a full picture of the tax that's gone to them. Remember, I've deliberately overstated my tax. So, statement of worldwide assets and liabilities, a statement of all financial accounts operated. That used to be bank accounts, but it could mean other accounts now, slightly wider than that. A certificate of all financial cards operated, used to be credit cards, and a certificate of full disclosure, which has to be witnessed now. So there are formalities to closing the COP9, and they are part of the COP9 deal. If they aren't signed, then you could be taken out of COP9, and HMRC may take a different view and may prosecute. Just an interesting little slide here about this parliamentary research briefing in November 21 that tried to distinguish evasion and avoidance, or tried to put in pen to paper and come up with a definition of the difference between the two. And this is from the House of Commons Library. Evasion clearly is where someone acts against the law. The other one, the avoidance, is where they try to pin it down by saying, well, someone's compliant with the law, though they're aggressive and abusive in trying to avoid tax, as opposed to simple tax planning. So what I'm trying to say, the more complex planning, more likely it is to be avoidance. And they say it's where the taxpayer will seek to comply with the letter of the law, but will try to subvert its purpose. And what that means is open to definition, but that's how difficult it is to actually pin down a definition of what avoidance is. You know, seek to comply with the letter of the law, but subvert its purpose. You know, arguably, if you subvert the law, you're deliberately doing it, and isn't that evasion? The line is very, very fine, and it's difficult sometimes for HMRC to find. That's the sort of parliamentary research briefing definition of avoidance. Essentially, you could read that the more complex the planning, the more likely it is to be you're trying to avoid tax. That then puts you into COP 8, potentially. HMRC's take on evasion is that you're deliberately submitting tax returns, you're claiming false repayments or reliefs, you're hiding income, gains, wealth offshore. I would argue you'd be hiding onshore as well, but they should say offshore, or you're smuggling taxable goods. And they will prosecute where the fraud is particularly serious, where they want to send a strong deterrent message, or where they say their civil powers aren't enough to uncover the truth or recover tax. And that was all taken from the FIS technical note of July this year. Just on that sending a strong deterrent message, very often they'll find a celebrity, sort of well-known person to prosecute if they can, because that's their prosecution. And on that point, you'll remember I said I'd mention a case later. Bernie Ecclestone was the case I was going to refer you to, where he failed to declare an offshore trust with assets of about £416 million in there. He actually got a 17-month imprisonment, but it was suspended for 2 years at Southwark Crown Court. So he was one of those suspended sentence people, as I mentioned earlier. So 17 months suspended 2 years. But, you know, and for a guy in his 90s, it's quite a tough sentence. Arguably, if he was younger, he may well have gone to immediate custody. But interesting in that case, he was offered a Code of Practice 9, and but he gave misleading statements. He made untrue statements. He gave documents that were false, and essentially he denied that he was the settler or beneficiary of this offshore trust that HMRC were looking at. It was only that the Singaporean tax authority gave HMRC some information about that trust, which showed that Bernie was not only the settler, but he was the beneficiary as well. So it was a settler-interested trust, and the tax position for that is that all income is assessed on the settler as it arises. So he was avoiding tax that way, but he didn't tell the truth about him being the settler and the beneficiary, and that's what undid him. So he wasn't, as he wasn't cooperating in Code of Practice 9, he was taken out and was prosecuted. Now, since know that the Fraud Investigation Service is now headed by Deputy Director Zoe Gascoigne. She was formerly a prosecutor at the Crown Prosecution Service. I think she headed their Serious Economic Crime Division. And she came over to HMRC from the Crown Prosecution Service. So she's a prosecutor. So her instinct is to prosecute. And she restated the terms of Code of Practice 9. So I think it was in June 2003 that those terms were stated, and essentially did was reiterate that Code of Practice 9 is a direct alternative to prosecution. It restated the terms to say that if you didn't comply, you'd be taken out of Code of Practice 9. And that's what happened in the Ecclestone case. And it essentially sort of reiterated that you're lucky you aren't being criminally prosecuted. And she restated those terms because she went there as a prosecutor and was surprised that a deliberate evasion of tax could be dealt with under civil investigation. So she's the deputy director that leads that for HMRC, FIS at HMRC. So I wonder whether we'd see more criminal prosecutions going forward because of her background. But that's a guess. So that's Code of Practice 9, Code of Practice 8. They are serious, particularly Code of Practice 9. You need specialist help. We're always here to help on anything like that. If you just want to chat or sort of brief guidance, you can always make contact. Always have to have that on that. But really do remember the framework, and remember you've got to cooperate within Code of Practice 9. But I want to move on to alternative dispute resolution, and where that fits in with dealing with HMRC and negotiating a settlement with HMRC. The alternative dispute resolution is a mediation, and where you can't reach an agreement with an officer, sometimes because they've become entrenched or the taxpayers have been entrenched. It's very sometimes to have someone previously connected with the case to try to break the deadlock. And an HMRC, the mediator is an HMRC employee, so they are an HMRC officer. And if you go into ADR and confess and it's a deliberate tax evasion, they are an officer of HMRC, so they would have to deal with that. And ADR used to be entirely or pretty much without prejudice. So you're at the tribunal. Anything you said, wouldn't you be put to be re-said in a tribunal hearing? That's not so anymore. So you do need to be careful what you say in a mediation meeting, because it can be used in a tribunal case. An HMRC officer can say at the tribunal, well, you said this when we were in that meeting. So you have to take ADR cases very seriously and be careful what you say. And as the taxpayer has to be there, if you're an advisor, really do train your client on when to do things, not do things. I did a system with one client where if I raise my right hand off the table, it's time for him to stop talking. But it's important they do talk, because they need to be seen to engage. But with a taxpayer in front of HMRC, with 2 officers, usually as a minimum, and the HMRC mediator as well. So there's 3 HMRC officers in the room. You do need to train your client when to stop talking, and you come up with whatever system works for you. But mine is to lift my right hand off the table, and then that's a sign that to stop talking, and I can say. The HMRC take over with the decision, and they still will be the decision maker all throughout the case. The mediator doesn't take that over. They just try to get both sides talking. HMRC say that cases that are suitable for ADR are where the communications are broken down. So the relationship between the taxpayer and the officer hasn't gone well. They're winding each other up, if you like. Moving forward, not necessarily on the facts, but it's not moving forward because of personalities. Then ADR is very, very good for that. Similarly, where the dispute is not moving forward because of the facts, ADR is good as well. And that could be that there is a misunderstanding, that you think HMRC have misunderstood the facts you've presented to them, or you don't understand why they haven't agreed the evidence you've given. So I've given you this. What is it about this evidence you don't like? Or you're not clear on how they come to a conclusion based on evidence they've got. You sort of say, well, I don't know what makes you say that. So they're the sort of cases that are ideal for ADR, because they're the sort of cases that can move. And ADR is quite successful. And we'll come to some figures in a moment, but HMRC like ADR, and I do. I was always a fan of litigation, because I thought if you had a legal argument with HMRC, the best place to argue it was before a judge. But I have to say, in the last 6 years, I'm real for mediation. I think they really do work. And I think it's great where you've got an officer, for want of a better phrase, who's a keyboard warrior. Their letters and their emails are very hard, very unforgiving, very unmoving. It's interesting sometimes when you put them in a room, or virtual room as it is now, say, well, here's the taxpayer, here's the person you're saying you don't believe, tell them why you don't believe them. How different that person can become. And I've seen one officer that was immovable move completely to our side. So it really does work. And remember, that officer that's entrenched, if it is the officer that's entrenched, is conducting this mediation with a colleague, so in front of a colleague, but also in front of the mediator as well. So, you know, he's got two colleagues, or she's got two, they have got two colleagues that they're acting in front of. So they need to have that in the back of their mind as well. And you know, that's another good thing for mediation. The officer's not at home on his own being the keyboard warrior. He's now in front of his colleagues as well. So they can assess his behaviour. And ADR is brilliant. There are cases that aren't ADR. ADR is not for where you want to make a complaint about an officer. There is a separate system from a tier 1 complaint that belongs to a tier 2 complaint. Mediation is not about complaints. You can't use mediation when there's a criminal investigation. It's as simple as that. You can't mediate your way out of a criminal prosecution, sadly. We've appealed to the tribunal, and the registrar has categorised the case as paper or basic. They are not suitable for ADR because they will be decided on the lower levels within the first tier tribunal. For those that are interested, the other two routes at the tribunal, basic's the bottom one, paper, it then goes up to standard and then complex. So standard cases and complex cases are eligible for ADR. It's the paper and basic that aren't. And for those that are really interested, if you're in the standard route, the costs follow the event, so you pay your own costs whether you win or lose. If it's in complex route, the loser pays the winner's costs unless the taxpayer opts out of that regime. Other cases that aren't suitable for ADR are debt recovery, payment issues. So when you're trying to negotiate a time to pay arrangement, you can't bring the collector into a mediation. That's something you need to negotiate directly. Disputes about tax credits aren't eligible. Default surcharges, late payment or late filing penalties aren't suitable for ADR. And that's because generally dealt with paper or basic cases at the tribunal. You can't have ADR about pay-as-you-earn notices, extra statutory concessions, high income child benefit charges, national minimum wage, accelerated payment notices, and follow-up notices. So other than that, you can apply for ADR. And when you do apply for ADR, there is a mediator decides whether the case is suitable for ADR, and they decide if you apply to ADR, that mediator will decide whether it's suitable or not within 30 days. Once you're in ADR, then we'll come to the process in a moment. So most applications are made where ADR, most applications for ADR is where HMRC has made a decision about a direct tax issue. They've not offered a review, or you accepted a review and had the conclusion, or you've rejected the offer. So in those last two cases, you'll need to appeal to the tribunal first and then apply to go into ADR. And with direct taxes, where HMRC has made a decision about a tax issue, and you've either accepted a review, in which case you have to wait for the review conclusion letter, or you've not accepted the offer of a review. Again, you'd have to apply to the first tier tribunal before you apply for ADR. But it is possible to consider ADR at any point during a compliance check. As I say, it usually happens when a decision has been made, because you want to get that officer to change his decision. It's usually when a review has been passed as well. The past review, and it's not what you're so it looks that you apply for, or you notify an appeal to the tax tribunal. You wait until that appeal is listed. HMRC then have 60 days to submit their statement of case to the tribunal and the taxpayer. And it's at that point you've got the whole of HMRC's legal basis for their argument. And that's pretty handy to have before you go into ADR, because you know what they're going to say at the tribunal. If you apply for a say at the first tribunal, it will almost always be granted by the judge. Rule 3 of the tribunal procedure rules makes it incumbent upon the judge of the tribunal to make the parties aware of mediation. So under Rule 3, an application for mediation will almost always be granted. So you've got your live appeal with the tribunal, you apply for a stay pending the mediation. That will always be granted. I can't imagine where it wouldn't be granted by a judge of the tribunal, given that Rule 3 come on a tribunal to point out the issue. So, once you go into ADR and you've gone down that route, you've got their statement of case, which is a pretty handy document to have going into that negotiation. So what are the outcomes for ADR? Well, the best outcome is that you convince HMRC of the merits of your case and they reverse their decision. Once they agree that in mediation, that becomes a binding decision under either Section 54 of the Taxes Management Act or Section 80 of the Value Excise Act. So that agreement within mediation is binding on both parties. And if you've got a tribunal case, you notify the tribunal and they say the matter's been agreed under Section 54 or Section 85. So that's the best outcome, and that happens. You know, we regularly have cases where we have convinced HMRC that they won't win at the tribunal. And the beauty of having ADR is you've got the officer in front of you, and you can, in a way, in a less formal setting, cross-examine. And then how the witness stay at the tribunal. And they're the same for you. They'll look at your client, the taxpayer, and say, well, now what sort of witness will they make at the tribunal? So if nothing else, the mediation is good to suss out how good or bad an HMRC officer will be at the tribunal. If the HMRC officers are bad within ADR, and they know that, they won't want to go to tribunal. So that's the best result. You should convince them, and they drop all of the assessments that they're seeking to engage with the client. That's it could happen the other way. HMRC may convince you of the merits of their case, and you agree with their tax analysis, and you agree, and it becomes binding as well. So you might go into ADR and say, this officer's really good, he's going to make an outstanding witness at the tribunal, whereas my client isn't as able as this officer, and that will be a weakness for us. You know, they may convince you, and if they do, better to agree in ADR than go to the cost of a full hearing at a tribunal. But disposal of ADR is that you agree some things but disagree others. And that's great, because what you've done is you've narrowed the issues before the tribunal. And the judge will love that. The parties have gone away and said, rather than have a day hearing over everything, we've got a half-day hearing with narrowed issues. So all we're asking the tribunal to adjudicate on is these issues. And that's a good result, because that means that you're not spending longer at the tribunal at the cost to your client than you need to. It also gets the tribunal judge on side, because there's not a lot of extra material that they don't need to go through. It's just narrow the issues. And that could be either way. You know, you could convince HMRC to agree some of what you're arguing. They might agree or get you to agree some of what they're arguing, and you might find a middle way and agree a bit each. And the other thing is ADR might completely foul, and you might not agree anything, and then in which case the only route left is the tax tribunal. But the judge will be happy at the tax tribunal because you've tried, and that's what they want to see at the tribunal, that you've tried to mediate, you've tried to negotiate a settlement, and you really can't. So route left to a judge and their member colleague to make a decision. Now, according to HMRC in 2023-24, there was 1,309 applications for ADR. And these figures are now really interesting. The cases they accepted were 512. So that's 39.11% of cases accepted. So that means the rest didn't go to ADR. Of that 1,309, 512 accepted. 334 were rejected by HMRC, so they're not suitable for ADR. 326 were rejected as outside the scope of ADR, so something doesn't fit within the parameters of ADR. 66 were withdrawn by the applicants, and 71 are awaiting that triage decision. But remember, the mediator has 30 days to decide whether or not to accept a case into ADR. So 71 of those. So 39% accept only, 25.5% rejected by the governance panel, 25% thereabouts out of scope, 5% withdrawn by the applicant, and the other 5% awaiting triage decisions. 367 cases were closed in 23-24, of which HMRC say 307 were resolved. So 83.65% were resolved at mediation. So those figures are interesting, and mediation is actually, as I say, very, very worthwhile. No doubt that you'll have many questions. Given the time I haven't taken to do this webinar, but my email is there and I'll put it up again at the end. But look, we're always very happy at Gravita to have a conversation, to have a call, to have a chat about anything you want to talk about with your clients. And, you know, that doesn't necessarily mean that we'll take over the case and charge you, but we will if you want to. But if you just want a call or a second opinion or just a chat about something about the next, you're unclear on the next step, whether it's investigation matter, whether you want to go mediation, or just how to respond to HMRC generally, get in contact with us and we'll have a chat with you free of charge, and we're always happy to help where we can. Let me just mention some upcoming webinars because they're coming up on us very shortly. Tim Palmer, one of our tax consultants, some of you may know, is doing an IR35 update and planning webinar. Very useful. IR35 doesn't go away, it's still there. Tim's going to run through from those. We're also having a sort of panel we're hosting at JPC about commercial property, the tax, VAT, and legal implications around transactions of commercial property. And that's on the 5th of February, again at 9 o'clock. And then Tim's back on the 20th of February for tax planning of own managed businesses. Always keen to listen to Tim on that. So do tune in. So that's the 15th of January, 5th of February, and 20th of February, all free of charge. Two of them by Tim and one by panel session. So you get to see different people from Gravita, and we're all here to help. Thank you very much for joining today. I know I've sped through a lot there. There's only so much you can say in an hour or so, but as I say, we are always open to having a chat with you about your clients or anything we can do to help. So do let us know. My email address is there, which I'll leave up for a bit. Don't hesitate to contact me. Always happy to